Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about the kind of crazy notion of whether an heir can knock you off to receive their inheritance. All right, the reason I'm making this video a little bit out of the ordinary is that, over the years, it's not that uncommon for somebody in my presence as we talk about estate planning to tell me something like, Paul, if my nephew knew the amount of money that I was leaving him, he might just have me knocked off. Or maybe I'll hear something like when, parents have saved their whole lifetime and they haven't disclosed to their children the value of their estate, and the parents think that their estate is much larger than the children think the parents' estate is. Parents may and I may ask, do your children know what you have? And they'll say, no way. And they might say, if my son-in-law knew how much we had, he might have me killed so my daughter would inherit. So I know sometimes those comments are made in jest, but I've been having enough of these conversations with many, many thousands of people over the last 3 decades to know enough to know that sometimes people are kind of serious when they make those statements. So I thought I'd kind of sort through it, let you know what the law is, so maybe you can sleep a little better at night knowing that it's not going to do anybody any good from an inheritance or a life insurance standpoint to quote unquote knock you off. Okay, so all states address in some manner what's commonly referred to as this slayer statute. And I'm going to go over my state, Louisiana. We have got a few statutes that are related, but I'm going to kind of point out one in particular that says a successor, and that's a person who would be entitled to inherit, shall be declared unworthy, and I'll talk about what unworthy means in a minute. A successor shall be declared unworthy if he is convicted of a crime involving the intentional killing or attempted killing of the decedent, or is judicially determined to have participated in the intentional, unjustified killing or attempted killing of the decedent. So what they do there is they cover it if there's been some criminal determination that a person has been found, criminally responsible for a death, they can't inherit. But also it covers the civil. If someone is civilly liable for a death, then that also precludes them from receiving an inheritance. So I talked about how a successor shall be declared unworthy, and it says a judicial declaration that a person is unworthy has the following consequences. Number one, the successor is deprived of his right to the succession to which he had been called. That means if someone is declared unworthy, or they either criminally or civilly were found to have participated in the killing, then they get nothing. Now, I will say it also talks about the attempted killing, and that's pertinent here because here in Louisiana we gotta have another crazy statute, and it says a successor shall not be declared unworthy if he proves reconciliation with or forgiveness by the decedent. So if nephew kills Uncle Moneybags, that reconciliation is not possible. But I guess it's possible if nephew attempts to kill Uncle Moneybags, but he's not successful at killing Uncle Moneybags. Then later, when Uncle Moneybags dies, nephew could say, you know what, Judge? I realize I tried to kill Uncle Moneybags, but a few months, he didn't die. And a few months later, we reconciled. So now that Uncle Moneybags is dead, I ought to be able to get my inheritance. So I can't see that going over so well in a courtroom, but nonetheless, that exists. Now, that's our kind of estate succession rules. We have similar rules when life insurance, and you see that a lot in the TV shows, 48 Hours or whatever it is that people put out there, where they get a life insurance policy on someone and then they kill that someone, and they seem to never get away with it. But here we have, no beneficiary, blah, 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 shall receive, blah, 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 when the beneficiary is either held by a final judgment of court of competent jurisdiction to be criminally responsible for the death, disablement, or injury of the individual insured, or B, judicially determined to have participated in the intentional, unjustified killing of the individual insured. So they've got it covered both on the kind of estate probate side, and then they've got it covered on the kind of life insurance side. Thank goodness. What is this world coming to where you have to have all these statutes in place to actually explicitly state that someone can't inherit if they kill or attempt to kill someone else? So bottom line there, if you're looked at from the other side, if you're thinking of concocting a ploy to knock somebody off to either receive an inheritance or to receive some life insurance, think again, because you're not going to get the inheritance and you're not going to get the life insurance that you think that you would get, and you may very well spend the rest of your life in the slammer. Okay, so hope that helps. Make sure you turn the gray like button blue, and if you haven't already subscribed, hit the notification bell so you don't miss anything. YouTube will keep you informed of my future estate planning videos. We'll see you next time.